Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and today we're going to be talking about Medicaid planning for an individual that does not have a spouse. If you are interested in today's handouts from the webinar, feel free to download those in the handouts portion of the GoToWebinar dashboard. And if you have any questions throughout today's program, feel free to type those into the questions tab of the GoToWebinar dashboard as well. Again, my name is Amber Hines, and I have been working with elder law and estate planning attorneys for the last 15 years to help their clients secure Medicaid eligibility by using a Medicaid compliant annuity. I am insurance licensed in all states, and I hold a Series 65 license with FINRA as well. And I created Ashbur to assist advisors and attorneys with pre-planning solutions as well as crisis Medicaid planning solutions for your clients. How we can help you and your clients. We offer a variety of different services and products. We offer complimentary case analysis, which is basically helping you to determine the optimal annuity amount, the term of the annuity, and which assets we would recommend being annuitized. If your clients have existing life insurance policies, annuities, or IRAs that need to be converted into a Medicaid compliant annuity, we can assist with that process and the actual funding of the annuity by doing a 1035 exchange or a direct trustee to trustee transfer. We offer assistance from the beginning to the end of a case. If you need us to provide quotes or assistance with the actual funding of the annuity, we can help with that. And then if you are in a situation where you have a client that passes away while they have an annuity in their name, then we would assist with the death claim process. In a lot of these cases, the state Medicaid agency must be named as a beneficiary. And so we would assist with reaching out to the state Medicaid agency to see if there is any lien on the annuity. And if there is, then we would help with sorting out the death claim process with the state as well as with the contingent beneficiaries. We work with A-rated insurance carriers, and we can offer annuities as short as a 2-month time frame, which you'll understand the need for a short-term annuity when we go through today's case studies. We offer top-notch customer service. We have a 24-hour turnaround time as far as getting back to you with a proposal and with any questions that you have for your clients. And again, today we're going to be talking about Medicaid planning for an individual client that does not have a spouse. And so when we're looking at an individual client that does not have a spouse, there's going to be income and asset limitations for Medicaid qualification. When we have just an individual client that is not married or they are a widow or widower, then we are looking at spending that client down to an asset limitation of $2,000 or less in most states. There is some variation to this asset limitation. A state like Missouri allows a client to have around $5,000 of liquid assets. A state like New York is significantly higher than that. But the majority of states, the individual Medicaid applicant cannot keep more than $2,000 of countable resources in their name. When we're looking at the income limitation for an individual, we must prove that the Medicaid applicant has more expenses than what they have it as countable income. And so that's usually not that hard to achieve when we're looking at a nursing home cost of anywhere from $4,500 a month up to $20,000 a month. Most clients don't have income from Social Security or a pension that is going to meet what the care cost is. So in most states, we're going to need to prove that the care costs exceed what the monthly income is from all sources. There are some states that are considered to be income cap states. If you are in an income cap state, then the client must establish a qualified income trust or a Miller trust. if their income is currently greater than around $2,500 a month. If their income is greater than that $2,500, then the income would flow through the qualified income trust or through the Miller Trust in order for the client to meet the income limitation for Medicaid qualification purposes. Some of the other resources that are going to be considered non-countable or protected assets for an individual are the individual's home, a car, household goods and personal property, an irrevocable funeral trust or a prepaid burial. And then some states do consider the IRA of the Medicaid applicant to be a non-countable asset as well. Something to note is that just because these items or these assets are going to be non-countable for Medicaid qualification purposes, it can become difficult to do planning for an individual that has a home that we're trying to qualify for Medicaid, because there's not really any income that's going to be allowed to maintain that home if we're going to qualify them for Medicaid. And also another thing to consider is that these items, like the home, could be subject to estate recovery if the client does go on to Medicaid and they still own that home. So just because they are non-countable for Medicaid qualification purposes, it doesn't mean that they're completely protected assets from estate recovery. And it looks like there was a question here on the income test. Somebody is asking if the income for the income test is gross or adjusted gross income. That would be the client's gross income cannot be more than the 2,500 unless, well, you would need to set up a qualified income trust if the clients have income that is greater than that 2,500 in their gross income, if you are in an income cap state. If we look at a client that has excess assets, we generally are going to develop a Medicaid eligibility plan, which may include converting countable assets into non-countable assets by making home improvements or improving the car or other non-countable assets. If you have a client that has a very small spend down amount and we don't have to spend much money in order to get them spent down to the $2,000 asset limitation, then we may be able to just do a prepaid burial policy or a prepaid funeral policy to get them to the asset limitation. Also, if your clients have credit card debt, mortgages, or other debt that needs to be paid off, we may be able to spend them down to the $2,000 by paying off some of these expenses. But if there is a large spend down amount that we can't spend down really any other way, then we can consider purchasing a Medicaid compliant annuity that would comply with the Deficit Reduction Act of 2005. When we look at Medicaid planning with annuities, Medicaid planning with an annuity is always going to be a single premium immediate annuity that is used in order to convert countable assets into an income stream. We would never be looking at using a tax deferred annuity, because a tax deferred annuity is going to be considered an asset for Medicaid qualification purposes, because there is cash surrender value that can be accessed out of a tax deferred annuity. A SPIA, or a single premium immediate annuity, is simply considered an income stream once we convert the lump sum of money into an income stream. And it would be offered by an insurance company. There's hundreds of insurance companies out there that offer immediate annuities, but there's less than 10 companies currently that offer a Medicaid compliant annuity. A Medicaid compliant annuity is going to be a specific type of SPIA that has specific language in it that would comply with the Deficit Reduction Act of 2005. The language that you would be looking for in a SPIA that would meet the Deficit Reduction Act of 2005 requirements must have all of the language that you're seeing on the screen. The annuity must be completely irrevocable, meaning that we can't change any aspect of the contract after it's been issued. SPIA on its own is going to be considered irrevocable as to the payment stream because you can't change the payments once an annuity has been annuitized, but a Medicaid compliant contract must be irrevocable in all regards as far as the beneficiary, the payee, the owner of the contract, who the annuitant is. We can't change any aspect of the annuity after it's been issued in order for it to be considered Medicaid compliant. The annuity must also be non-assignable, meaning that a company like J.G. Wentworth or Peachtree, companies that buy annuities on the secondary market, would not be interested in buying this type of annuity because it cannot be assigned over to a third party. Also, the annuity must make equal payments without any balloon or deferral of payments. The annuity must be actuarially sound. This test is met by having the annuity structured for a time frame that is within the client's Medicaid life expectancy. If I have a client that has a remaining life expectancy of 10 years, then as long as the annuity is structured to pay out within a 10-year time frame, then it would meet the actuarially sound requirement because it's structured shorter than the life expectancy, but is not longer than the life expectancy. And then finally, the state Medicaid agency must be listed as a remainder beneficiary to the extent that Medicaid benefits are provided on behalf of the Medicaid applicant. The planning opportunities that involve a Medicaid compliant annuity when we have a single individual that is seeking Medicaid eligibility, we're usually going to be looking at one of two options for a single applicant. We first would consider a gift and annuity plan, and second, we would consider a standalone Medicaid compliant annuity plan. Most people are familiar with the first option, the gift and annuity strategy, because this is used most frequently when we have a client that has a longer life expectancy. The second option, the standalone annuity plan, is really only used when we have a client that has a pretty limited life expectancy because the state has to be named as the beneficiary on both of these annuity plans. We're going to look at a single person case study. We have an individual named Mary, and Mary is 80 years of age. After living at home with dementia for years, she's now in need of nursing home care. Mary's family feels that she could live for another 10 years in this sort of supportive care environment. Her total countable assets, which are all after-tax dollars, money just sitting in the bank, is around $205,000. She has monthly income from Social Security and pension of $2,000 per month, and the private pay rate at the nursing home is $10,000 per month. The Medicaid reimbursement rate at the facility that she is at is $8,000 per month. The Medicaid reimbursement rate, a lot of people ask where they can find this number. Some states publish the reimbursement rates on the Medicaid agency website. Others, you would have to actually call the facility and try and get the Medicaid reimbursement rate, and that's really going to come into play in our second example. First, we would need to determine what Mary's monthly income shortfall or what her deficit is. The nursing home is currently charging her $10,000 per month. She only has monthly income of $2,000 per month, so she has a shortfall each month of $8,000 when we subtract her $2,000 of income from the nursing home cost at $10,000. This is where the income test would come into play. It's usually not that hard to prove if you have a client that is needing care in assisted living or in a nursing home, and they're spending drastically more on their care than what they have in income, it's not hard to prove that they have an income need because they're spending so much on their care versus how much income they have. If Mary does no planning at all, we would be looking at her running out of her assets within just over a 2-year time frame. She has $205,000 of liquid assets or countable assets remaining. If we divide that by the $8,000 a month that she is short from being able to pay her nursing home, she is going to run out of the $205,000 within a 25-month time frame. And because Mary's family anticipates her living for many more years, doing no planning at all is not going to be a great option for her, because after that 25-month time frame is up, after she's spent down all of her $205,000 in assets, she would need to qualify for Medicaid at that point anyways. And so we're going to look at a plan that would allow her to keep some of the resources or preserve some of the resources and then use the other money to purchase an annuity. Our first option is the gift and annuity plan. And the goals of a gift and annuity plan is to allow a single Medicaid applicant that does not have a spouse to make an immediate wealth transfer or a gift to their intended beneficiaries. This usually is going to be a gift to children or to an irrevocable trust, depending on the amount of the gift or the transfer. After the gift is made, we are going to allow the client to qualify for Medicaid after the ineligibility or penalty period has expired that's associated to making a gift. So by making a gift, we know that there's going to be a period of time that Mary needs to privately pay, because Medicaid has a 60-month look-back period for any gifts or transfers that are made that are not returned, or where the Medicaid applicant does not receive fair market value in return for the gift. I like to think of the gift and annuity strategy in terms of buckets of where the money is actually going. As a result of the Deficit Reduction Act of 2005, in order for a penalty period or a private pay period to start, the Medicaid applicant must be income and asset eligible. So if we think about 3 different buckets of money where the client is going to transfer money to, the client is going to keep around $2,000 or less in resources. I usually have them keep around $1,800 in assets, or $1,500. Then the client is also going to make a gift or a wealth transfer with part of the money. And then part of the money is going to be used to purchase a Medicaid compliant annuity. So out of the $205,000 that Mary has in assets, the $205,000 is going to go into one of these 3 buckets. Either it's going to be used to purchase the annuity, it's going to be gifted, or it's going to be kept as part of the $2,000 asset limitation that Mary can keep. First, we're going to determine the monthly income shortfall, and this is, again, just taking the monthly income of $2,000 and subtracting from the cost of care at $10,000 per month. She has a shortfall of $8,000 per month. We're next going to determine the burn rate, and this is determined by taking the monthly income shortfall at $8,000 per month and adding that to the divestment penalty divisor at $10,836 per month. And we determined that the burn rate is $18,836 per month. Many people ask, what is the divestment penalty divisor and where can they find it? In this example, the divisor that I'm using is $10,836 per month. This is a state that is in the northeast area of the country, and so that cost of care may be higher than what it is in a state that you live in. This number is supposed to be an average cost of 1 month in a nursing home in your state. And this is a number that Medicaid publishes either on their website or within their Medicaid manual that would indicate how the state calculates what the penalty period or the ineligibility period is for Medicaid qualification based on how much is gifted out of the client's name. So if we have a gift of, say, $100,000, and I'm in a state where the divisor is $10,000 per month, then this individual would be ineligible for Medicaid for a 10-month time frame. But if I was working in a state where the divisor was only $5,000 per month, then I know that the penalty period for a $100,000 gift would be 20 months. So this does basically, it matters where you're located in the country as far as what the average cost is. If you're unsure what your divisor is in your state, we also publish that information on our website if you need to find that information. Next, we're going to determine what the penalty period or term is, and we're going to use the spend down amount or the total assets that Mary has at $205,000, and we're going to divide that by the burn rate that we determined at $18,836, and we determined that the term of the plan in this case is going to be 10.88 months. We round that 10.88 months up to an 11-month time frame to determine the gift amount in this case. The gift amount is going to be determined by taking the term of 11 months and multiplying the divisor in this state of $10,836. And we determine that Mary is able to gift $119,196 of the $205,000 in assets. Next, we're going to figure out how much money can be used to purchase the Medicaid compliant annuity. And we're going to do that by subtracting the gift amount of $119,196 from the total assets of $205,000. We determined that the annuity amount is going to be $85,804. The $85,804 is going to be used to purchase an 11-month annuity, and that 11-month annuity is going to make a monthly payment of $7,801 per month. You'll notice that the total payout of $85,811 is going to be slightly more than the single premium, just a couple dollars. That's going to be the interest that the insurance company is going to pay back to Mary when they make these payments back to her. You'll note that the annuity can only be structured for a whole number of months. It would either need to be a 10-month time frame or an 11-month time frame. I can't do a 10.88 month annuity time frame. It has to be a whole number of months, which is why I rounded this penalty period up to 11 months, and also I have the annuity structured for an 11-month time frame. During the ineligibility or penalty period, Mary's total income is going to be $9,801 per month, and that's determined by taking the annuity income that we created at $7,800 and adding the Social Security and pension income that Mary already had at $2,000 per month, and we determined that her total income with the annuity is going to be $9,801. During the private pay period, Mary's total cost of care is going to remain at the $10,000 per month. And when we subtract out her Social Security, pension, and annuity income at $98.01, we determine that her monthly income shortfall is $199 per month. Many people ask why we have to have a monthly income shortfall in a case like this and why we can't just create the full $10,000 per month that Mary would need in order to meet her out-of-pocket cost of care. And the answer comes down to we need to establish that the client is eligible for Medicaid from an income and asset standpoint. So we have spent them down to $2,000 or less in assets, and her income is less than her cost of care. And so she would be income and asset eligible for Medicaid, but she's not eligible because she has made a gift within the 60-month look back period. If we were to create exactly the amount of income that Mary needed to pay for her cost of care, or if we created more income than the $10,000 that she actually needs to pay for the nursing home, then Medicaid is not going to start the penalty period because she would not meet the income test for Medicaid qualification purposes. So in this type of scenario, we are intentionally creating a shortfall that the client must have, and really it comes down to how comfortable are we to create a $50 a month shortfall versus a $500 a month shortfall, and we can work into the numbers backwards, but there has to be a shortfall of some kind in order to meet the income test. The economic results of doing the gift and annuity plan is that Mary was ineligible for Medicaid for an 11-month time frame, which is the private pay or penalty period. During that period, Mary had monthly income of $9,800 per month. Her shortfall, again, was $199 per month during that private pay period. And a lot of people ask how that shortfall is paid. Depending on the amount, it can either be paid from Mary's resource allowance of $2,000, or if it's a larger shortfall, then some of the money from the gift may need to be used to cover that shortfall. But in a lot of these cases, the shortfall is small enough that we're able to cover it from the $2,000 asset limitation that Mary would keep. Mary would become eligible for Medicaid in month 12. The advantages of this type of plan is that Mary's children received an immediate gift of $119,196, which is more than 50% of the assets at $205,000. And with the gift being made with after-tax dollars, we're really not concerned about any income tax consequences of making the gift because the $205,000 was just money sitting in checking or savings. So we're not liquidating an IRA or a pre-tax account in order to make the gift in this case. And then Mary is going to receive Medicaid benefits in month 12. The disadvantages of the gift and annuity plan is that if Mary does not live through the 11-month private pay period, she's not going to have received any economic benefit from Medicaid because Medicaid is not going to start covering the cost of care until month 12 after the private pay period is over with. And so in any case like this, life expectancy is going to be a factor, and how long we anticipate that person to live for is going to really drive which plan we would suggest going with. If we assume that Mary passes away 6 months after the annuity is purchased, the state Medicaid agency must be listed as the primary beneficiary like we talked about to the extent that Medicaid benefits are provided. Since the annuity in this case was being used to pay during a penalty period and Medicaid would not have started paying until month 12, the state being listed as a beneficiary in this case really doesn't come into play as far as the state having a right to recover against the annuity. So assuming Mary would list her children as the secondary or contingent beneficiaries, they would receive whatever is remaining in the annuity or 5 months worth of payments after Mary passes away. In a situation like this, we would need to contact the state Medicaid agency. They would provide us with a clearance letter that indicates that Mary was never on Medicaid and the state didn't pay anything on Mary's behalf. And once we receive that letter, then the secondary or contingent beneficiaries would be paid whatever is remaining in the annuity contract. If we instead assume that Mary passes away 12 months after the annuity is purchased, what happens to the annuity? Nothing, because the annuity was structured for an 11-month time frame. It would be done paying in 11 months. So Mary passing away in month 12 or any time after the 11th month is not going to have any impact on the annuity because it's done paying out after the 11-month time frame. If we look at the time frame to get an annuity and a gift plan in place, usually we're going to have the client make a gift, purchase the annuity, and apply for Medicaid all in the same month. We're doing this in order to establish that the applicant is asset and income eligible for Medicaid, so they're eligible for Medicaid, but for the gift or transfer that is made. And once you make that Medicaid application and prove that the client is income and asset eligible, then Medicaid is going to start the penalty period or private pay period, and they're going to send a letter that is going to outline what the penalty period is and how long that period is. We would be doing all those calculations on the front end to determine what the penalty period is associated to the gift that's made. And so the annuity is going to be used to pay during the penalty period. And then after that penalty period is over, then Medicaid is going to start paying and the client is going to be considered Medicaid eligible at that point. If Mary has a limited life expectancy versus a long life expectancy, then we may consider going with the second option, which is a standalone Medicaid compliant annuity plan, where Mary is not going to make a gift. But in our first scenario, Mary's family believed that she was going to live for another 10 years or live for a time frame longer than the 11-month time frame. So it made sense to go with the gift and annuity strategy. But if we have a client that we don't anticipate living for very long, then we may consider this second scenario, because in the second scenario, Mary's family is not anticipating that she'll live more than a 12-month time frame. The second option is to use a standalone Medicaid compliant annuity, and the goals in this case is to obtain immediate Medicaid eligibility without any gifting of assets. So there's not going to be any private pay period in this second scenario because we're not intentionally making a gift or transferring assets out of Mary's name. The goal would be to take advantage of the Medicaid reimbursement rate that we talked about at $8,000 per month versus the full private pay rate at $10,000 per month. And we are trying to create a wealth transfer to Mary's family after Mary passes away in the second scenario. So instead of her making a gift while Mary is still alive, our second example is the children receiving a wealth transfer after Mary passes. You may recall that if Mary does no planning at all, she was going to exhaust all of her resources within just over a 2-year time frame, and we determined that by taking the $205,000 and dividing by the $8,000 a month shortfall, and we calculated a 25-month time frame that Mary would have exhausted all of her assets. We're going to, in order to secure immediate Medicaid eligibility for Mary, we're going to eliminate the excess resources. She would only be able to keep $2,000 in her name as countable assets in order for Medicaid to start paying. She has $205,000, and so in order to get Mary income and asset eligible for Medicaid, we would use a Medicaid compliant annuity in order to convert the $205,000 into a Medicaid compliant annuity where Mary is the annuity owner, she's the annuitant, and she's also the payee. With Mary being 80 years of age, she has the remaining Medicaid life expectancy of almost 10 years, or 9.83 years, 117 months. And like we talked about in our first scenario, annuities can only be structured for a whole number of months. And so 117 months in this case is going to be the longest annuity term that we could purchase for Mary based on the fact that she is 80 years of age. If she was 90 years of age, then the annuity is going to be structured for a shorter period of time because she has a shorter life expectancy based on her age. We would take the single premium of $205,000 and we would put that into a Medicaid compliant annuity structured for 117 months, which would create monthly income of $1,775. The total payout on the annuity is $207,675, which again is a small amount of interest that would be paid by the insurance company as the annuity makes payments back to Mary. In this scenario, if we're thinking about this in terms of buckets of money, in order for Mary to be Medicaid eligible, she must be spent down to $2,000 or less. And so she's going to keep around $2,000 in assets, and then she's going to use the other $205,000 in this case to purchase a Medicaid compliant annuity to convert the excess resources into an income stream. You'll notice here that there isn't any gift or transfer money that is being allocated to the children. We're just going to use the full $205,000 to purchase the annuity to spend down the assets. By converting Mary's countable assets of $205,000 into a Medicaid compliant annuity, we're able to get Mary immediately eligible for Medicaid, and we're able to reduce her copay to the nursing home down to $3,725 per month. We're going to add Mary's Social Security and pension income at $2,000 plus her annuity income that we just created of $1,775. Her total income is going to be $3,775. And then we're going to subtract out her monthly personal needs allowance. In this state is $50. So her copay to the nursing home on a monthly basis is $37.25. The monthly savings by getting Mary immediately eligible for Medicaid and not making any kind of gift is that Medicaid is going to immediately start paying. So instead of Mary paying $10,000 per month for her care, we were able to reduce her patient liability down to $37.25, and she would immediately experience a monthly savings of $62.75 per month. If we assume that Mary passes away 6 months after the annuity is purchased, then you'll recall that the state Medicaid agency must be listed as the primary beneficiary to the extent that Medicaid benefits are provided. Because Mary is immediately eligible for Medicaid, Medicaid is immediately starting to pay. So this is where the Medicaid reimbursement rate at the facility is going to come into play, because this determines how much the state would have a right to recover against the annuity. If the Medicaid reimbursement rate at this facility is $8,000 and Mary has a copay of $37.25, the amount that Medicaid was paying for Mary's care on a monthly basis is $42.75. And if we multiply that by the 6 months that Mary survived, then the state is going to be looking to recover $25,650 from the annuity contract. The amount that Mary's children are going to receive in this case, if we consider that Mary passes 6 months after she purchases the annuity, is going to be $168,700. This is determined by taking the annuity single premium, or the amount used to purchase the annuity initially, at $205,000 and subtracting out the annuity payments that Mary received while she was alive. So that was $1,775 per month times a 6-month time frame. That's $10,650 that she received. And then also we're going to subtract out the payment that the state is going to recover against the annuity at $25,650. And when we subtract those from the $205,000, we determine that Mary's children in this case are going to receive $168,700. The advantages of the standalone annuity plan is that Mary was immediately eligible for Medicaid. There wasn't any private pay period or penalty period where Mary was paying out of pocket. She immediately received a savings of $2,000 per month, and this is the difference between the private pay period and the Medicaid reimbursement rate. Some states, there's a pretty large variance in the private pay rate versus the Medicaid rate. And if there is a big variation in those numbers, then it may make sense to do the standalone annuity plan if you have a client that you're not anticipating living for a long period of time. After Mary passes away, she was able to make a wealth transfer of $168,700. And you may recall that if Mary proceeded with the gifting plan in the first scenario, her children received around $119,196 in that scenario. So with the limited life expectancy, we see that the wealth transfer after Mary passes is actually greater in the second scenario than it would be in the first. The disadvantages of the standalone annuity plan is that if Mary lives longer than what we initially anticipated, the wealth transfer is going to be reduced accordingly. Because the state has to be the primary beneficiary, and because she is immediately eligible for Medicaid, every month that Mary lives for longer than what we anticipated, then the state is going to have a greater claim against the annuity. If Mary is anticipated to live for an extended period of time, then it's better to go with option number 1, where we are making a gift and then purchasing the annuity to pay through a penalty period. We would need to know what the Medicaid reimbursement rate is at the facility that the client resides at, because some states have a rate equalization where the private pay and Medicaid rates are the same. And if you're in a state that has that, then it's more than likely going to make sense to go with option number 1, because you're not getting a huge savings with option number 2 if your private pay rate and the Medicaid reimbursement rate are going to be the same. In the second example, if we assume that Mary passes away 12 months after the annuity is purchased, we understand that since the state is going to be the primary beneficiary, that the amount owed to Medicaid is going to increase the longer that Mary lives. So in this second scenario of Mary living for 12 months versus 6 months, now the state is going to have a right to recover $51,300 from the annuity. If Mary lives for 12 months and passes away, then the amount that Mary's children are going to receive is going to be $132,400. This is again determined by taking the annuity payments, 12 months worth of payments at $21,300, and also subtracting out the payment to the state at $51,300 from the original amount used to purchase the annuity, so that we determine that Mary's children are going to receive $132,400 in the second scenario of her living for 12 months. The steps to implement a standalone Medicaid compliant annuity would be to determine how many assets the client has, have them keep the $2,000 of assets that they can keep, and then purchase a Medicaid compliant annuity with the excess spend down amount over the $2,000, and then submit a Medicaid application and prove that the client is income and asset eligible for Medicaid. Medicaid eligibility would be immediately obtained without any kind of penalty period or private pay period in the second scenario, because we are not making a gift out of Mary's name. Which strategy is better, option number 1 or option number 2? We talked about that this Medicaid applicant's anticipated longevity is really going to dictate which plan is better based on the client's life expectancy or anticipated longevity. That's going to drive whether option 1 or 2 is the better option. We need to know what the Medicaid reimbursement rate is at the facility that the client is looking at. And then if we have a single Medicaid applicant that lacks capacity and the POA documents don't allow for gifting, then we may need to go with option number 2 if we're not able to make a gift out of the client's name in order to do the gift and annuity strategy like we talked about in option number 1. And then finally, if you are in a state like North Dakota, Oregon, or Washington, we may be forced to go with option number 2 because these 3 states have actuarially sound requirements, which may not allow us to do a 10-month time frame or a 11-month time frame like we talked about, because the annuity must be structured based on what the client's actual Medicaid life expectancy is. In those 3 states, we would most often be going with option number 2 for a single Medicaid applicant, because we're not able to shorten the annuity term to something like an 11-month time frame like we talked about. And it looks like I have some questions from people here. Somebody is asking if we have an abbreviated version of the presentation that they can share with clients. We do. I can send over that to you through email. So I'll email that to you this afternoon. And it looks like that is the only other question that I have here. Somebody is asking if Pennsylvania is an actuarially sound state. Yes, so all states require that the annuity must be paid within the client's Medicaid life expectancy. It cannot be, the annuity cannot be longer than the life expectancy. But the 3 states that I mentioned, North Dakota, Oregon, and Washington, they have requirements where the annuity must be structured within like 12 months of the actual life expectancy. So if I had a client that had a life expectancy in Oregon of 120 months, then I would have to do an annuity term of 120 months or within 12 months of that 120-month time frame. And so doing an annuity for an 11-month time frame to meet the gift, the penalty period associated to making a gift wouldn't work in those 3 states because I'm not meeting that more restrictive definition of actuarially sound in those states. So you're correct that Pennsylvania is a state that requires the annuity to be actuarially sound like the rest of the country does, but these 3 states make it very difficult to do the gift and annuity strategy because they don't allow for the very, very short term annuities like the rest of the country does. Somebody is asking about receiving a copy of the PowerPoint. It is in the handout portion of the webinar. Otherwise, I can email that over to you as well. Okay, I think that is all of the questions. If anybody thinks of any questions that they have for me, feel free to call the number that you're seeing on the screen or shoot me an email at amber@ashbur.com. I want to thank everybody for taking time out of their day to join me. And next month, we're going to be talking about gifting and annuity plans for a couple where both spouses are in a nursing home and we're looking to do a gift and annuity strategy for both of them. If you have any questions, feel free to email or call me. And again, thank you and have a great day.